Hello, everybody, and welcome to History Bite number 91, dated October 24th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled Writing a Case Brief. Now, if you are in law school or college or graduate school, and you take any law-related courses, it is very likely that at some point you will receive a case brief as an assignment, but do not run in fear. For the record, a case brief is nothing more than, in this context, a brief analysis of a case that has been decided in an appellate court. All right? The hard work has already been done. You're just providing an overview of what happened and what was the outcome. Now, each and every single professor will have their own particulars with respect to what they want included in a brief, what they don't want included in a brief, how long they want it to be, how short they want it to be, and so forth and so on. My video will provide for you a base model example of a case brief, okay? And you will use this in concurrence with any instructions your professor may give you in writing the case brief. If they would like something included that my list does not have, by all means include it. If they want something excluded that my list has, get rid of it. Following directions is very important in higher education, all right? So, follow the rules your instructor gives you, but of course, use my video, okay, for assistance in the nuts and bolts of writing a basic case brief. I've written enough of them in my time, all right? So, there are 7 elements of a basic case brief, all right? And I'll go down the list before I explain each one of them. Number 1, the case name and citation. Number 2, okay, the facts of the case. Number 3, the legal question or questions presented in the case for the appellate court to decide. Number 4, the opinion of the court. Number 5, the laws applied. Number 6, any applicable concurrences or dissenting opinions. And number 7, the judgment of the court. So going down this list, number 1, at the very top of your brief goes the case name and citation. This is very important. If you omit this, we will not have a clue as to what case you're talking about. All right? So let's take, for example, a U.S. Supreme Court case, Obergefell versus Hodges. All right? And the citation is 576 U.S. 644, 2015. Okay? Read simply, that citation means that the case of Obergefell versus Hodges is a U.S. Supreme Court decision found in volume 576 of the U.S. Reports, page 644, all right? And the case was decided in 2015. So that's your case name and citation. Number 2, the facts of the case. Very important. With the facts, you are boiling down mountains and mountains of complex, dense, and much of it irrelevant information to point out the most pertinent details and particulars of this case. What made it a lawsuit in the first place, okay? And if there is any prior judicial history to it, you should include that as well in the facts section, all right? Be detailed in your facts, but don't go overboard, all right? Remember, this is a brief, okay, not a dissertation. All right. You want to explain exactly what happened in the background in this case, what made it a lawsuit in the first place, and any prior judicial history. Okay. Number 3, the question or questions of law presented, okay, in the case to the appellate court. For example, in Obergefell, the legal question presented: does the 14th Amendment require states to recognize same-sex marriages? Okay, that is a perfectly valid legal question that was presented to the Supreme Court to answer. All right, and they did. All right. Number 4, the opinion of the court. This is the court's official decision in that case, and it includes the rationale that they use to defend that decision, for better or for worse. All right? That's not for you to critique. You are simply putting it out there, what the court ruled, and the defense of that decision, the road they took, all right, to get there. Number 5, the laws applied, okay? Now, this section, in my opinion, is optional, okay? But you may want to add it so that it can be clear as to what language in the Constitution or other relevant federal laws the court used to reach their decision, okay, and to base their decision upon, essentially, okay? This is optional, but in the case of Obergefell versus Hodges, the court rested its opinion on both the Due Process Clause and the Equal Protection Clause, both contained in the 14th Amendment. So the Due Process and Equal Protection Clauses of the 14th Amendment were what the court based its decision upon in Obergefell versus Hodges. All right. Number 6, any concurring or dissenting opinions. All right. In Obergefell versus Hodges, dissents, the majority opinion, of course, all right, stands aside from these concurrences and dissents, in case one may not have been aware of that, okay? So then concurrences and dissents, no concurrences were filed, but 4 dissents were filed. One by Chief Justice Roberts, one by Justice Scalia, one by Justice Alito, and one by Justice Thomas. All right? The majority opinion, for the record, was written by Justice Anthony Kennedy. Okay? But speaking of concurrences and dissents, this too is optional, along with the laws applied. I only recommend adding concurrences and dissents so that you can provide a full overview of not only the majority's holding, but the attempts to undermine. But with the concurrences or dissents, okay, if there are none to speak of, then obviously this section is totally off the table. But if there are concurrences or dissents, you do not write what those concurrences or dissents state. You merely add the justice's name and whether or not they wrote a concurring or a dissenting opinion to the case. All right? So, again, this is optional. If no justices wrote a concurrence or dissent, don't worry about it. All right? And even if they did, if your professor doesn't want you to add that, don't add it. Last but not least, the judgment of the court. The judgment is essentially the total and complete disposition of the case and what the Supreme Court required at the very end. The judgment will typically read, with respect to the decision from the lower court, affirmed or reversed or affirmed in part affirmed in part and reversed in part, or reversed and remanded for a new trial. Okay? The judgment will indeed be found at the very end of the majority opinion in the case. Okay? So those are the 7 elements of a case brief. Okay? And I'll repeat it before I let you go, that numbers 5 and 6, number 5 being the laws applied, and number 6 being any relevant concurrences and dissents. These 2 sections are totally optional. They are not required for a sturdy and comprehensive brief. You only add those if you want to add a comprehensive analysis of the case, in positions that the opponents of the decision used to challenge it, and with the laws, the applicable constitutional provisions or other federal laws that the court rested its decision upon. So real quick, one more time, 7 elements of a case brief. Number 1, the case name and citation. Number 2, the facts. Number 3, the question or questions presented for the court to decide upon. Number 4, the opinion of the court. Number 5, the laws applied. Number 6, any concurrences or dissents, if applicable. And number 7, the judgment. Okay? So if you have any questions, controversies, or whatnot, do leave them down below and I'll be happy to answer. Take care, stay safe out there, and I'll talk to you at the next History Bite. Peace.